Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Georgia and how to recover your property in 4 simple steps. Let's jump in. At eForms, we simplify essential legal documents to make life's important decisions easier. Need an eviction notice for Georgia? Click the link in the description to download yours and start the process today. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state conditions can be found on our website. Legal reasons for eviction in Georgia. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee the following notice. Non-payment of rent. If the tenant is late on rent, you can serve the tenant a 3-day notice to pay or quit. For lease violations other than non-payment, Georgia law allows landlords to terminate the lease immediately, provided they notify the tenant in writing before demanding possession. Let's cover rent grace period. In Georgia, rent is due on the date listed in the lease. There is no grace period unless otherwise specified in the lease agreement. Let's cover the 4 steps to legally evicting a tenant in Georgia. Serve the notice to quit. A landlord must serve their tenant a notice to pay or quit or a notice demanding possession in all instances before filing an eviction action in court. The notice must be delivered personally or via certified mail and posted on the tenant's door. File eviction papers with the court. If the tenant doesn't fix the problem or fails to vacate upon demand, you may file a dispossessory affidavit with your local court. Serving the tenant. After filing the affidavit, the tenant needs to be served the dispossessory warrant, typically by a sheriff or process server. Wait for a judgment. After receiving the notice, the tenant has 7 days to respond with an answer. If the tenant files an answer, a hearing may be set. But if they do not respond, you may request a writ of possession from the court. If awarded, you can then contact the local sheriff's office to remove the tenant and their possessions. Let's go over damages. Often the tenant's security deposit does not cover total losses. The court will usually enter a judgment compelling the payment of any rent owed, court and attorney fees, and other damages to the landlord related to the lease. If damages are not awarded at the hearing, you may be able to recover losses through small claims court or by filing a distress action. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below. Thanks for watching, and don't forget to subscribe for more.